just grab people and pat them down, you idiot. What's wrong with you?
Where's your ID at?
What?
Because I said so.
Because you said so?
Yeah, because I said so. You're taking pictures of all... Yes. Where's your ID at?
Where's your ID?
Where is your ID?
Where's your ID?
Do you see it?
I see a name tag. I don't see an ID. I want to see your address and everything.
Why? Is that where you're getting your information from?
You want to see
so you can see it? Yeah, because you're taking pictures of government property right now. Where's your ID at?
I don't know what to tell you.
Alright, I'm going to pass you down for weapons.
No, you're not.
Yes, I
No,
am.
you're not. You
Yes, I
can't
am.
touch me. You can't. I'm recording this.
Too.
I'm not putting my phone down. I'm allowed to record this. You can't.
I don't care if you're recording now.
You just grab me and pat me down. What's your name? Name is you. You don't get to pat me down. What is this is public property, that's public property. What's your name?
Public property, is there
That's
a gate?
public property. It doesn't matter. Can I see through the gate, you ignorant bitch? Learn the laws.
And these are the people that are meant to be helping us.
As many of you guys know, I'm a law enforcement trainer instructor. I train and instruct military law enforcement all over the country on various law enforcement disciplines to include constitutional law, case law, patrol tactics, use of force, etc. And here let's just call it what it is. This is not a good look for law enforcement at all. This female officer, from what I'm looking at, she's either unhinged or just having a super bad day today. And so I'm not gonna hold water for anybody. I will call out things exactly as I see them, because at the end of the day, as law enforcement, yes, are some days better than others? There are, but society and the world does not care. I know this is a hard pill to swallow, especially for those of you that are thinking about law enforcement, thinking about going into law enforcement. Are you going to have bad days? Yes, but you can't let your bad days cross the line, because when they cross the line into criminality, when you violate somebody's life, again, the society does not care how bad your day is. They don't. You violate somebody's rights, you're on the chopping block. Those good graces of, I've had a bad day, they don't matter. And so that's something that I think is very important for young rookie cops to know, and for people wanting to get into this line of profession. You don't get to have bad days. You don't get to have that as a justification for your poor action. So with that being said, let's jump straight into the case law. As you can see here on your screen, this is a case law we talk about routinely. And unfortunately, we have to talk about this case law routinely because law enforcement continuously mess this up. So we're going to keep talking about it until we don't have to talk about it anymore. So here we go. Brown v. Texas, 1979. The United States Supreme Court has affirmed that law enforcement needs reasonable articulable suspicion, RAS, in order to detain and compel somebody to identify themselves. Here, it's very clear. The female officer was not able to articulate any reasonable articulable suspicion. We do know that he was taking pictures of government property. So again, let's bring up the flag-burning case law here. Texas v. Johnson, 1989. The Supreme Court has held that flag burning, for example, constitutes symbolic freedom of speech that's protected by the First Amendment. The Supreme Court further held that freedom of speech protects actions that society may find very offensive, but society's outrage alone is not justification for the suppressing of free speech. This person is engaged in a lawfully protected activity under the First Amendment, freedom of speech, freedom of press. So this female officer's outrage at this person lawfully engaging in a First Amendment protected activity does not rise to the level of which she can now take criminal enforcement or take law enforcement, which would be, in this case, she's trying to compel and demand him to identify himself. Now, with that being said, we really need to flush out two more things here because it's extremely important. Let's talk about Terry v. Ohio, 1968. The Supreme Court held that if a police officer has reasonable suspicion that an individual has a weapon which poses a danger to an officer, the officer may stop that individual to search the individual for a weapon. Now, with that being said, we need to have reasonable articulable suspicion of an encounter, right? If you're going to have an encounter in which you're trying to detain, you're compelling somebody to not move. You have seized their person. You have detained them. You are compelling identification. Okay, well, you need to have reasonable articulable suspicion before you can do that. Another thing to think about, too, during, for example, a Terry frisk or a Terry pat down, there's a very good argument to make that it is a seizure, right? Torres v. Madrid, 2021. The Supreme Court, again, further held that the application of physical force to the body of a person with the intent to restrain is a seizure, even the person does not submit and is not subdued. So if you're doing a pat down, the person pulls away from you and says, no, I don't want to be a part of this pat down, and you use physical force to conduct that pat down, congratulations, officer. You have seized that person. You have effectively seized them, according to the Supreme Court. You have detained that person. So it goes back to, again, Brown v. Texas. If you did not have reasonable articulable suspicion to detain that person, you violated their rights. And when you violate somebody's rights, you can have your qualified immunity removed. You can have actions imposed on you criminally and civilly. Again, this is basic academy stuff, guys. This is basic academy stuff. And here we have officers in modern day 2025 missing the mark. Every single day, missing the mark. And so, again, training needs to be had. Emotions and egos need to be put in check, because unfortunately for law enforcement, or fortunately for law enforcement, depending on how you want to look at it, the people are fed up, and they are. I expect 2025 to be. I expect 2025 to be an interesting year for case law, because of what we have going on with different various executive orders. I expect it to be interesting in the guys that people, as we can see, people are getting fed up. And so it's going to be a very interesting year, I think, from a case law standpoint, to see what comes out, what is adjudicated. So there you have it. Hope this video was helpful for you guys. If you guys like the video, like, share, subscribe. And as always, guys, long live the Republic.